Welcome to American Court Case. Like the video, share with friends, subscribe to the channel, and
Court martial present by video conference. As you can see and hear from your device, your lawyer is present in person in court. Speaking to the microphone, Ms. Hasso, and tell the court, are you Marisa Escobedo Hasso?
Yes, Your Honor.
Welcome to court, Ms. Hasso. The court martial present in person. Ms. Hasso, do you have a lawyer?
No.
Ms. Hasso, will you be going forward without a lawyer?
Yes, Your Honor.
The court marks you self-represented. Ms. Flores, does the court have Ms. Hasso's email address?
Yes, Your Honor.
Mr. Trevino, what is the announcement?
Your Honor, I believe the court set this hearing or this date for temporary orders, and the court had on June 5th had signed a temporary restraining order that I guess the petitioner had applied for. My client was not served with that petition for or motion for temporary restraining order. Your Honor, the court signed it. It affected personal property that my client has, including the Jeep that he uses exclusively, and it's requesting, and the quote, I believe she's also requesting temporary spousal support, Your Honor. But this application, it fails procedurally, and it fails to establish any of the legal elements required in an ex parte hearing or for a motion for temporary restraining order. So we're requesting that this order, the order itself, be dissolved. Now, as far as the temporary orders, Your Honor, I was just recently hired. My client was served with notice of this on Sunday, June 14th, and we're requesting a continuance on the temporary orders. But as far as the motion for temporary restraining order, we're requesting the court dissolve, or at least put it in abatement so that we can have more time to prove up all of the allegations of the petitioner. We filed an answer yesterday, Your Honor, and in our answer, we're alleging that there is no marriage, and there's no pleadings that allege the elements necessary for the marriage, either in the petition or in the temporary motion for temporary orders or motion for temporary restraining order as well.
Three questions. First question, Mr. Trevino. The only thing that differs, I think, from the temporary restraining order that the court signed and the standing orders in family law in Webb County is the use of a Jeep 2023. Is it your client's position that he should have use of that vehicle?
Yes, Your Honor. He has exclusive use. He's been making payments on it. He currently resides in Utah. He was transferred with the Texas National Guard. I think he was transferred over there for assignment. And that's his personal use of that.
And the vehicle is where?
In Utah with him.
Second question, other than the provision on the Jeep, is there any provision in the orders that the court signed or any orders that you would request in the future that differ from the Webb County standing orders?
Well, Your Honor, they do, because all of the property that was alleged or requested or affected by the temporary orders, both the temporary orders and the motion for temporary restraining order are the personal property of my client. There's nothing on the record. There's nothing in the deed. There's no, we provided by an exhibit A and B that she's on, that she has that
there's
property.
No specific property listed, only the Jeep.
Actually, Your Honor, she listed, I believe, the residence 21 Villa Lane.
Don't speak until I ask questions. Give me 1 second. You'll have plenty of time to.
Yes, Your Honor. It's 15. I believe it's 15.
But that wasn't signed by the court.
I believe it was, Your Honor.
Tell me the date.
On June 5th. That's on the court. If that's the case, then I'm mistaken. Then that must have been on the temporary orders.
It might have been requested, but the only property affected, other than things outside of the scope of the standing orders, is the Jeep. Third question. It seems, based on a review of the record, Mr. Trevino, that Mr. Gonzalez was served and the affidavit of service reflects June 14th. You're just saying that he didn't get served at the time it was entered, but you're not claiming he isn't served now?
He's served now, but he wasn't given adequate notice here.
Sure. Let me give you some time to respond. What would you like to say, Ms. Hustle?
I created an exhibit of, or kind of, of,
Just
Inaudible?
yes,
so speak louder and just tell me.
sorry. I created a exhibit of everything we shared together. We were a committed relationship for 4 years. We shared 2 homes. One was in a lease, which I was in. We shared a home which I have messages from the realtor where he's including myself. The Jeep, my mother is the co-signer for his Jeep. I shared utilities. I have cash out, so we joined bank accounts. We were engaged. I have pictures. I did create an exhibit of everything we shared within the 4 years.
And may I respond, Your Honor?
Mr. Trevino, have you filed a request for temporary orders?
No, Your Honor. We're specifically denying any marriage exists. We're not doing a counter petition because, again, there's no marriage in existence. That's what we're arguing. And so we're going to be requesting a motion for summary judgment very soon. I just got the case, Your Honor. So I'll be filing that very soon. And then we'll be providing more evidence. As far as the statements made by Ms. Hasso, the lease that she's arguing that she was on there, it says that they're cohabitants. It's mentioned the husband and the wife, Your Honor. In the deed, the second property, it lists my client as a male unmarried on that, and it only has his name on the deed. And as far as the cohabitation, there's nothing she's going to present is going to show that they presented themselves as husband and wife in public. The only thing that closely could be argued would be that they cohabitated together, but not as husband and wife. There's no children of the marriage.
So let me ask you two questions, Mr. Trevino. First question. You haven't filed a counterclaim, correct?
No, Your Honor. We filed just an answer.
Right. Because you're just going to defend and prove that she can't prove her case. So my next question is, I know you said you're going to file a summary judgment and the court welcomes you to do that. But if you do, then what the court needs to do is schedule a final pretrial hearing and then schedule a final hearing after that. The final pretrial hearing ostensibly would be for the court to give you a deadline to file the summary judgment based on the new Texas rules 166 with regard to summary judgments. If you went that route, a resolution in this case is going to take much longer. If we did this at a final hearing, then the case will be proven or equally defended, and you'll probably get a resolution in the next 45 to 60 days. If we went the MSJ route, the new rules allow for 90 days plus. So what would be your request on behalf of your client?
At this time, we're just requesting a reset for the temporary orders hearing, Your Honor, and then a final.
I can't do that because. So let me do this because Ms. Hasso, I find that Mr. Trevino is correct. If service wasn't perfected at the time that the court signed, then or shortly thereafter, then they should be dissolved. 1, 2, he's right. There is nothing in the record that shows why you should be given that Jeep. In other words, there are defects sufficient enough to cause the court to grant the request. So if Mr. Trevino doesn't have a request for temporary orders and now you don't have a request for temporary orders, there went that. So somebody here, if you want temporary orders, should file that request.
Your Honor, well, they sent me everything where he was served everything.
I agree with you on that. It's part of the court record. I've seen and reviewed it.
For that, it's also for my safety. He does have, I do have police reports in here, harassments where he's harassing me. I didn't leave the house voluntarily. It was harassment. It was, calling my employer. So I am also doing it for my safety.
I tell you what, the thing here is that since you filed self-represented, and since Mr. Trevino did not file a counter petition, no one here ostensibly has been provided the standing orders of Webb County. Ms. Flores, can you print out 2 copies, please?
Yes, Your Honor.
And for the record and for your benefit also, Ms. Hasso, these can be found on the county website to the district clerk under local rules and standing orders. And in those orders, as I communicated and asked Mr. Trevino, everything that you've requested already applies to this case. There can be no harassment. There can be no threatening communication. Anybody that's found in violation of any of this is subject to sanctions or other penalties by this court. So I'm going to give you a copy so that at least we're all on the same page.
And Your Honor, as far as the residence, Mr. Hasso is attempting to sell the property. He doesn't reside there anymore. It's here. She's left the house as of February of this year. She hasn't resided there, so she's been residing.
Why are you telling the court this?
Well, Your Honor, because in the standing orders, I believe there's, I don't know if it's G or H, that it addresses marital property, and there is no marital property.
There's nothing I can do about that. And the reason I ask why you're asking is because you successfully argued a dissolving of the temporary order. So there's no more temporary orders hearing. There's nothing left for the court to do.
Thank
so
you
can put it on the record, but the court's hands are tied until we get to a final hearing, unless somebody makes a request in writing.
Your Honor, could we have a final hearing, request a final hearing?
Well, it looks like, I take it back. It looks like Ms. Hasso and Mr. Trevino, this case is already scheduled for a final hearing September the 2nd at 2 p.m. If you need another setting earlier, make the request in writing and I'll be happy to entertain that request.
Thank you, Your Honor.
Anything else on this case, Mr. Trevino?
No, Your Honor.
Ms. Hasso, anything else that you would like to put on the record or tell the court?
No, Your Honor. Just, I was just seeking, like I said, I do have a lot of evidence here to where it does state that we were a committed couple. Bank accounts, I put my 401k, he was in the joint account. So all this is in here. That's why I was asking the court to preserve the share of property that we had together, because there was an incident where, like I said, there's a police report. After that police report, he locked me out of the home. So I had no access to the house. So everything that we purchased together, everything that we got together, I don't know what he did to it. So the reason why I was saying this is because he locked me out of the house. So I had no way to go in the house. I had no way to, we had furniture, we had, the police department themselves told them that he needed to give me access to the property. The only thing he gave me access to was the garage.
So a couple of things, Ms. Hasso. I don't know yet if any of that or all of that is true. It may all be true. It may all not be true, or something in between. But what's happened here today is that Mr. Trevino successfully procedurally knocked this case out until the final hearing. So at that time, the court welcomes you and Mr. Gonzalez to testify and to present evidence that everything you're saying is true and correct, and then he'll have the same opportunity to do that. What you need to know at this point, 2 things. First, just take a look at those standing orders. They're effective for you and for Mr. Gonzalez. Mr. Trevino will provide that to Mr. Gonzalez soon if he hasn't done so already. And 2, be on the lookout for your email, because at the time that you present your case, everything that you present to the court must be uploaded electronically to Case Center so that there's no surprises at trial. There's no trial by ambush. Everything is fully disclosed. Everything is can be fully presented. Do you have any questions for the court, Ms. Hasso?
No, Your Honor.
Mr. Gonzalez, do you have any questions for the court?
Excuse me. I do have one question, but I'll speak to my attorney about it.
All right. I look forward to hearing your case, Ms. Hasso and Mr. Gonzalez, on September the 2nd at 2 p.m. I wish you both very well. Have a good day.
Thank you, Your Honor. I believe that's everything I have.
Good to see you, Mr. Trevino. Have a good day.